whether the first respondent was eligible to contest the August 2021 presidential elections. In his submissions, the first respondent urged the court to uphold its previous decision in the Legal Resources Foundation case that he was eligible to contest the 2021 elections. It was further argued that this petition is incompetent as in essence it seeks to challenge the nomination of the first respondent outside the time frame prescribed in Article 52 of the Constitution. On their part, the petitioner and the third respondent submitted that the court interprets the combined meaning of sections 2 and 7 of the Act, as well as the repealed Article 35 of the Constitution, and urged the court to find that the inclusion of the first respondent on the 2021 presidential ballot was unconstitutional. The second respondent did not submit on this issue. We have taken into account the varying positions taken by the parties on this issue. In the Legal Resources Foundation case, in which the first respondent's eligibility to contest the 12th August 2021 elections was challenged, we stated as follows on pages J77 and J78. We find that Article 1063 of the Constitution does not bar the first respondent from contesting the forthcoming presidential election scheduled for 12th August 2021. For that reason, we hold that the first respondent's nomination, which was accepted by the returning officer on 17th May 2021, is valid, and that the first respondent, Edgar Lungu, is qualified and entitled to stand for election as president on 12th August 2021. At the time of the holding of the 2021 elections, our decision in the Legal Resources Foundation case was binding, thereby enabling the first respondent to stand for election as president on 12th August 2021. This we affirm against the backdrop of the well-settled principle that court decisions and orders are binding and must be obeyed unless set aside or expire due to a fraction of time. This is the view we took in the case of Bernard Kanengo versus the Attorney General and the Electoral Commission of Zambia. Therein, we held that we wish to state that the Court of Appeal does not have jurisdiction to hear appeals to cases whatsoever dealing with Article 52(4) of the Constitution. Nevertheless, that stay order it had issued had to be obeyed, even though erroneously issued, and remains in force until discharged or set aside. The declaratory reliefs 1, 2, and 3 sought by the petitioner, urging this court to declare that the Electoral Commission of Zambia's inclusion of Edgar Lungu on the 2021 ballot and his participation in the August 2021 election unconstitutional are therefore hereby dismissed. Amicus curiae. We now wish to refer to the brief filed by the friend of court, Mr. Sangwa, State Counsel. A review of his filed brief reveals that the gist of Mr. Sangwa's submission is that there is no provision in the Constitution that vests authority in this court to interrogate eligibility of a losing presidential candidate to take part in the election, post-election, which he has lost. He further submitted that a decision of the court in favor of the petitioner in that respect will not only affect the first respondent, but all those who took part in the 2021 elections without the court hearing them. Further, that it would also question the legality of the 2021 presidential election that included an unqualified candidate. However, and in view of our finding that the first respondent was cleared to stand for election as president in accordance with the decision of this court, Mr. Sangwa's submissions and arguments are of no consequence. Whether the first respondent is eligible to participate in any future presidential elections. In his submissions, the petitioner submitted that the first respondent does not qualify to participate in any future elections under the Constitution. This, he argued, is due to the fact that he has served 2 full terms and will therefore be in violation of the Constitution if he attempted to seek a 3rd term. It was submitted that the first respondent participated and won a presidential election in 2015, which culminated into his 1st term under the repealed Article 35 of the Constitution. Further, that for the 2nd term, he was elected under the Constitution as amended in 2016, and that this Constitution does not apply to his 1st term as it has no retrospective effect. The court was urged to depart from its decision in the Legal Resources Foundation case, as it had completely omitted to take into account the provisions of Section 2 of the Act and was therefore per incuriam. The first respondent, however, submitted that the majority decision in the Legal Resources Foundation case comprehensively dealt with his status, that the said decision upheld the decision in the Daniel Pule case, in which it was held that the 1st term cannot be considered as a full term for purpose of Article 106, sub-Article 3 of the Constitution, and that, therefore, Article 106 of the Constitution did not bar the first respondent from contesting the August 12, 2021 election, and by extension, future elections. It was also submitted by the first respondent that the legal resources case was not per incuriam, as the dissenting judgment made reference to Section 2 of the Act, which meant that the judges were aware of this provision. It was further argued that this petition was wrongly before this court, as it had come by way of an appropriate, as it had not come by way of an appropriate motion for review of the court's earlier decision. The court was called upon to uphold its earlier decision in the Legal Resources Foundation case. The first respondent is urging us to uphold our decision in that case, as the decision was correct and binding. In its submissions, the second respondent relied entirely on the answer, affidavit in support, and skeleton arguments filed on 16th November 2023. In his submissions, the third respondent submitted that the Legal Resources Foundation case did not pay particular attention to, nor did it take into consideration, Section 2 of the Act. It was further submitted that there was no need to provide for transitional provision in Section 7 of the Act, as the issue at hand was catered for in Section 2 by the definition of which constitutional provision applied on the effective date. Further, that the repealed Article 35 of the Constitution was clear in speaking to twice elected and not holding office. That the first respondent was therefore deemed to have twice held office and was barred from participating in any future elections. It was also submitted that ultimately, whether the issue has been pleaded or not, the court is being called upon to invoke the per incuriam rule. This court, in its majority decision in the Legal Resources Foundation case, asked itself a question as to whether framers of the Constitution in the transitional provisions under the 2016 constitutional amendments made provision for what was to happen to the incumbent president's term of office, which according to the court straddled 2 constitutional regimes. The court then looked at the provisions of Section 7.1 of the Act and came to the conclusion that the said provision shows that although the Act provided for the continuation of the President in the office of President, it made no provision for how the period served from January 2015 to September 2016 was to be treated in view of the change in the constitutional provisions from the limitation based on being twice elected to holding office for 2 terms. The court then proceeded to draw inferences on what the framers of the Constitution must have intended, and based on the provisions of Article 106 of the Constitution, concluded that Article 106, Sub-Article 6 of the Constitution, regarding the full term, must be applied to defining what is meant by twice held office in Article 106(3) in interpreting the provisions of that article. Based on the above, the court then proceeded to conclude that the term served by the first respondent from 25th January 2015 to 13th September 2016 was an inherited term and not a full term as defined by Article 106, Sub-Article 6 of the Constitution. Consequently, it was held that Article 106, Sub-Article 3 of the Constitution did not bar the first respondent from contesting the 12th August 2021 elections. We have carefully considered the arguments by all parties in this petition. First, we wish to correct the misconceived view suggested by the first respondent that this matter is an application for review. To the contrary, our firm view is that the petition is beseeching us to depart from or overrule our previous decision in the Legal Resources Foundation case, as it was arrived at per incuriam. We note further that in that decision, there was no reference to Section 2 of the Act throughout the majority judgment, and a combined interpretation of Section 2 and 7 of the Act, read together with the repealed Article 35 of the Constitution, was never made. It is not in dispute that the first respondent was elected and sworn into office of President on 25th January 2015 under the repealed Article 35 of the Constitution. With regard to term limits, the repealed Article 35, 1 and 2 of the Constitution provided that Article 35, 1, subject to clauses 2 and 4, every president shall hold office for a period of 5 years. Article 35, 2, notwithstanding anything to the contrary contained in this Constitution or any other law, a person who has twice been elected as president shall not be eligible for re-election to that office. In 2016, the Constitution was again amended. The question, therefore, is, with the coming into effect of the 2016 amendments, what happened to the office of the president since his term was continuing up to September 2016? The answer to this question lies in the preamble to the Act, which states, "An Act to provide for the printing and publication of the Constitution, to provide for the savings and transitional provisions of existing state organs, state institutions, administrations, offices, institutions, and laws." From the wording of the above provision, it is clear that framers of the 2016 amendments had in mind transitional provisions or clauses to guide the administration of state affairs, including those relating to state organs, including the office of the president, so as not to create a vacuum. With regard to the office of the president, Section 7(1) of the Act provides that the president shall continue to serve as president for the unexpired term of that office as specified by the Constitution in accordance with the Constitution. The question that arises from the above provision is, which Constitution does Section 7(1) refer to? The answer to this question is to be found in Section 2(1) of the Act, which inter alia provides as follows. Constitution means the Constitution of Zambia 1991, in force immediately before the effective date. Effective date means the date of commencement of this act and the Constitution as amended, as provided in Section 4. From the above provisions, it is our considered view that quite clearly the first respondent's first term, which ran from 2015 to 2016, was served by the transitional clauses, and in particular sections 2 and 7 of the Act, and continued with the repealed Article 35 of the Constitution. In terms of the term limits, the repealed Article 35 was therefore applicable to his first term. Article 106 of the Constitution did not apply in retrospect, contrary to the holding in the Legal Resources Foundation case. The decision, therefore, is per incuriam. We accordingly depart and vacate that decision and previous decisions which made similar findings contrary to the well-settled principles of the law, that the law does not operate in retrospect unless it expressly states so. There is no provision that provides for the retrospective application of Article 106 of the Constitution. As we clearly stated in the case of Lucas Hamatowe and others versus Zambia Postal Services Corporation, when we said, it is trite that the law does not operate retrospectively unless there is a specific provision providing for the retrospective effect of the law. And there is abundant case law on this principle in this jurisdiction. Further, we said in the case of Lucky Mutambo versus Attorney General that if this court was to grant the petitioner's wish, it would be retrospectively applying the provisions of the Constitution as amended and reasonably without any lawful purposes, without any lawful basis, and ignoring the provisions of the Act number 1 of 2016. It is our conclusion that prayers A and B must fail. They are accordingly dismissed. Having considered the provisions of Section 2 and 7 of Act number 1 and the repealed Article 35 of the Constitution, we take the view that the decisions in Daniel Pule, Bambi Kapalas, and Legal Resources Foundation were arrived at per incuriam, as Sections 2 and 7 are clear that the first term that ran from 25th January 2015 to 13th September 2016 was captured by the repealed Article 35 of the Constitution. For this reason, we further dismiss the first respondent's argument that the question of his eligibility to contest the 2021 elections, and therefore this petition, is res judicata. As earlier guided, a matter cannot be res judicata, where a previous case was decided per incuriam. On the same footing, this petition cannot be said to be res judicata. For this reason, reliefs 4, 5, 6, 7, 8, and 9 have merit and are hereby granted. Before we leave this matter, we feel compelled in the public interest and as a guardian of the Constitution to put to rest a fundamental misconception about Article 106 of the Constitution. The matter before us was premised on the assumption that Article 106, Sub-Article 6 of the Constitution qualifies Article 106, Sub-Article 3, thereby enabling a person who takes up a prematurely vacated presidential term of office to vie for and serve a further 2 terms in office. This assumption that there is, in inverted commas, a 3rd term in Article 106, Sub-Article 6, has been the source of much public tension and uncertainty, hence the need for our intervention. In a bid to address the issue, the third respondent submitted extensively on the principle of mandatory alternation as a source of Article 106 of Article 3 of the Constitution and its antecedent, the repealed Article 35 of the Constitution. He contended that there was a contradiction between Article 1063 and Article 1066 of the Constitution, which ought to be reconciled or harmonized by ranking the two provisions so that sub-Article 3 is superior to sub-Article 6. That this would ensure that the latter did not essentially destroy the former. Although the point was not responded to nor argued by the other parties to the case, we are of the considered view that its import ought to be ventilated in the interest of protecting the integrity of the Constitution. We wish to elaborate on mandatory alternation, firstly by cross-referencing to the submissions recited in paragraph 4.12 and 413 at page J24. And secondly, by drawing support from Hector Fix Fierro and Pedro Salazar Ugarte, whose work entitled Presidentialism reads at pages 629 to 630 of the Oxford Handbook of Comparative Constitutional Law as follows. The source of legitimacy of presidential power lies then in a set of rules, in brackets, laws and institutions, that broadly correspond to the forms of modern democracy. More precisely, these rules provide for the necessary, regular and periodic replacement of the head of the executive power through popular vote. The renewal of the presidency is provided for in the Constitution and carried out at fixed intervals. Besides exceptional circumstances such as impeachment, death, resignation, and the like, the president stays in office for a fixed period, generally between 4 and 6 years, with or without the possibility of being elected for more than one term. The third respondent contended that Article 106 of Article 3 is the hallmark of mandatory alternation. With that in mind, we perused the first and final draft reports of the Technical Committee on Drafting the Zambian Constitution, TCDZC. The first draft report contains draft Article 103, which provides as follows. 1. The term of office for a president shall be 5 years. 2. Subject to clauses 3 and 4, a president shall hold office for one term, commencing from the date the president-elect is sworn into office, and ending on the date the election results are announced, and shall be eligible to be elected as president for a second term. 3. Notwithstanding anything in this Constitution or any other law, a person who has twice been elected as president shall not be eligible for election as president. 4. The president may, in writing, signed personally and addressed to the Speaker of the National Assembly, resign from office. In the words of the TCDZC, the rationale for the article was that it was important to limit the number of terms to be served by a president in line with the current Constitution, to avoid the tendency of an individual wanting to be in office in perpetuity. The committee therefore resolved to retain the provision in the current Constitution. The final report of the TCDZC shows at pages 285 and 286 that draft Article 103 was unanimously adopted by the people's representatives at a district consultative forum, the provincial conventions, the sector group convention, and the national convention without any change. However, the TCDZC amended the provision to include the issue of a vacancy in office and and the dimming, in inverted commas, of an inherited term. The recommended TCDZC final draft provision in draft Article 104 as a reason for amending the draft article to the draft article. The TCDZC said that it amended the article by providing for circumstances where the vice president or a new president serves an unexpired term for a president who does not complete his or her term of office. The committee observed that it was important to make a provision as to whether or not the inherited term should be counted. Draft Article 104 is replicated word for word in Article 106 of the Constitution. For convenience, we have set out Article 106 in its entirety. It reads, 106.1, the term of office for a president is 5 years, which shall run concurrently with the term of Parliament, except that the term of office of president shall expire when the president-elect assumes office in accordance with Article 105. A president shall hold office from the date the president-elect is sworn into office and ending on the date the next president-elect is sworn into office. 3. A person who has twice held office as president is not eligible for election as president. 4. The office of president becomes vacant if the president A dies, B resigns by notice in writing to the Speaker of the National Assembly, or C otherwise ceases to hold office under Article 81, 107, or 108. 5. When a vacancy occurs in the office of the president, except under Article 81, A, the vice president shall immediately assume the office of president, or B, if the vice president is unable for a reason to assume the office of president, the speaker shall perform the executive functions except the power to 1, make an appointment, 2, dissolve the National Assembly, and a presidential election shall be held within 60 days after the occurrence of the vacancy. 6. If the vice president assumes the office of president in accordance with Clause 5A, or a person is elected to the office of president as a result of an election held in accordance with Clause 5B, the vice president or the president-elect shall serve for an expired term of office and be deemed for the purpose of Clause 3A to have served a full term as president if at the date on which the president assumed office at least 3 years remain before the date of the next general election, or B, not to have served a term of office as president if at the date on which the president assumed office less than 3 years remain before the date of the next general election. Article 1063 of the Constitution, when read with Article 106, sub-Article 6 of the Constitution, provides that a person may or may not be deemed to have served a full inherited term. In common parlance, deeming relates to viewing or perceiving something in a contrived way. More formally, Black's Law Dictionary, 9th edition, gives as a main definition of the verb deem to treat something as if 1, it were really something else, and 2, it had qualities that it does not have. Hence, deeming allows an inherited term to count or not, depending on the length of time served. In our considered view, a contradiction between the two subclauses arises if the objective of the deeming is to enable the person who served an inherited term to contest more than one future presidential election, as it would create an exception. We have considered the issue on the basis of well-settled principle that constitutional provisions should be interpreted in a manner that harmonizes them. An exception to the clear prohibition in Article 106, sub-Article 3, would have to be explicit and cannot be imputed from the language of deeming, especially in the face of the people's expressed commitment to a maximum of 2 terms. Hence, the deeming can only be consequential as opposed to empowering or permissive. We are of the firm view that the words "be deemed for the purpose" are intended to settle post-presidential questions about the legal status and the entitlements of a former president, as opposed to providing for a person's eligibility to return to the presidency beyond the mandated 2 terms. On a holistic reading of Articles 1, 5, 8, 9, 118, and 267 of the Constitution, with Article 106 of the Constitution, we find that Article 106, Subarticle 6 of the Constitution, does not create a 3rd term. Final orders. Our combined interpretation, therefore, of Sections 2 and 7 of the Act and the repealed Article 35 of the Constitution is that the first respondent's term of office, that ran from 25th January 2015 to 13th September 2016, constituted a term of office. The first respondent's term, which ran from 13th September 2016 to August 2021, constituted his 2nd term. The first respondent, Mr. Edgar Lungu, has therefore been twice elected and has twice held office. Article 106(3) of the Constitution makes the first respondent ineligible to participate in any future elections as a presidential candidate. Our finding in paragraph 833 above does not affect the first respondent's participation in the August 2021 presidential elections. For this reason, we do not find merit in relief 1, 2, and 3, and they are considered and they are accordingly dismissed. Reliefs 4, 5, 6, 8, 7, and 9 have merit and are hereby granted. In light of the significant constitutional issues that have been raised in this matter, we order the parties to bear their own costs.
Much obliged.
We're most obliged.
This brings us to the end of today's sitting. We enjoin all those present in court to maintain silence until the court has risen.
Court rise. Your question, the Constitutional Court has just rendered a judgment based on pencurium that did not consider Article 35 and enabling Transition Act of Section 207 of 2016. What's your view about this?
Well, the view, first and foremost, to start with, sitting in that court and listening to the pronouncements of the bench gives you the confidence that we have a competent court, and it gives the hope to the Zambian people that there is a court, there is a constitutional court that can decide and determine their constitutional issues before it. What has come also to pass is that the court has given the direction that politicians may be popular, but when they have done their part, when they have served their term, when they have been sworn twice, when they have been elected twice, that's the end. They can do other things. There are many other things they can do. The court looked at the previous decisions which were made by itself, and it has been identified that they were given pencurium. Pencurium means that important legislation was not cited. Important laws were not taken into account when the court arrived at that decision. And this is what the court has come to terms with. That's why it has decided to vacate the previous decisions it made. Yes, it's bound by its previous decisions, but when it's discovered, like it has done now, that the court in the previous sittings did not take into account Section 2 and 7. That's why it has decided to vacate as the principle of pencurium.
Finally, is there a need to amend the Constitution to harmonize provisions in relation to having held office twice and not serving more than 3 years?
Really, that is for the Zambians. It's for the Zambians, either they don't like it, that a president should serve maximum 10 years. But for sure, in a population of 20 million, maybe in the future, 30 million, why should any person entertain ideas that they have the monopoly of wisdom? Why should we entertain ideas that there is only one person out of those many millions of people who can be president? It gives the comfort, even to those who intend to become presidents in future, that theirs is only a maximum of 10 years. It also gives comfort to those upcoming politicians that one day they will sit in that office to serve the people of Zambia.
Thank you so much.
Thank you.
Maybe that's last one. There have been articles going around on social media where people have been warning that if the case doesn't go in ECO's face, then there will be a constitutional crisis.
Thank you. Thank you very much. I think as a friend of the court, State Counsel Sangwa brought it out, and the court has been very emphatic that really it doesn't affect. Number one, the court said Edgar Lungu then was entitled to stand in 2021. So it doesn't affect at all. But it also helps that we should, when we go on social media, I observed that people were commenting, even warning. They are lucky the Constitutional Court has not summoned them to come and explain why they behaved in a contemptuous way, to start commenting about a matter which is in court. A warning to the Zambians, please don't be street or quack lawyers in the street to comment about matters that are in court, matters which have not been determined or judgment has not been given, so that the courts can administer, so that the court can determine the matter independently without hearing the noise you make out there. So please, let's respect the courts. When the matter is in court, it's sub judice. We shouldn't comment about that matter. We shouldn't. It's contemptuous. And especially when we see senior lawyers commenting, it means they have lost their steam. A lawyer who goes in the street and start commenting on matters which have not yet been exhausted, he has become a quack lawyer. That shouldn't be encouraged.
Just the last one. The Constitutional Court has ruled to say the former president was actually eligible to contest in 2021.
Yes.
Had he won, that I would have meant to say that's a third term and creating a constitutional crisis. The fact that the president is supposed to hold.
I wouldn't know. Had he won, maybe the people would have petitioned and maybe they should have brought that and the court would have looked at it in a different way or the same way. But for now, we can't comment what would have happened had President Lungu won in 2021.
Thank you, sir.
Thank you.